Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. While discussing the evidence class, normally we will be telling you in simple terms or simplest terms what is evidence. Evidence is what you see. Evidence is what you hear. Evidence is that's all. So definitely what you see, that is ocular evidence, direct evidence. It has having always the main place. The so-called medical evidence, expert evidence, fingerprint evidence, scientific evidence, all these things, they are only corroborative. Right? So mere difference between the medical evidence and the ocular evidence, medical evidence will not get the upper hand. You cannot reject the direct eyewitness account. This is what is stated in the case of Ramesh G. Amar Singh THAKOOR. Ramesh G. Amar Singh THAKOOR versus State of Gujarat in criminal appeal number 1183 by 2016, decided on 13/9/2023 by two judges bench. So Justice Aniruddha Bose and Madam Bela M. Trivedi of Honorable Supreme Court of India, where they dismissed the appeal and held the conviction by the Gujarat High Court is legal. So let us understand the facts of the case first. So here, by now, eyewitness account, you might have understood that is a murder case, right? So on 10/7/1995, at about 6:30 p.m., the deceased Jayanti Bhai, while he was in his house, three accused persons, so that is Ramesh G. Amar Singh and his two brothers, three accused persons came to his house or trespassed into his house and attacked him with knives. Of course, one is a long knife, other is a checheri or something they call in Gujarati language. And inflicted serious knife injuries, which actually the person, Mr. Jayanti Bhai, he tried to save himself by running, but he could run only for a few steps and he fell down. Ultimately, he was taken to the hospital, where before the arrival of the police, he died. And he narrated the story, that means he gave the dying declaration to PWs 4 and 5. PW2 is the wife. She narrated, she has seen the incident. She narrated the incident. Right, all the three accused, they were arrested, charge sheet, routine procedure has gone. But the trial court did not believe the version of the so-called eyewitnesses, even though they said that they were present, this man gave the dying declaration, others, they did not believe. A reason, medical evidence. So here, let us read the medical evidence also. Dr. Pratik Bhai Ranji Bhai, Dr. Pratik Bhai Ranji Bhai, he deposed that injuries number 3, 6, 7 and 8, that means total 8 injuries are there, right? So 3, 6, 7, 8, 4 they can be caused by the chari, that is a long knife, and which was recovered as per the confession of the accused, that is under section 27 of the Indian Evidence Act. A weapon was recovered, but please remember, the accused were 3 in number. They have used 3 weapons, and the eyewitnesses account is also there. And he stated that these particular ranges, that is 3, 6, 7 and 8, they themselves cannot cause the death. This is the evidence. So the other injuries, this is the long knife, other injuries are caused by the sharp knives. So the trial court believed the version of the medical officer and said that the account given by the witnesses, eyewitnesses is interested, it is contradictory, and so many points they have acquitted the accused. An appeal was filed by the state and the Gujarat High Court. They have taken into account of the so-called version of the eyewitnesses. The High Court is also opinion that eyewitnesses account. The perception of each person differs from, the perception will differ from person to person. The reactions will also be different. And there may be minor contradictions. Don't be under the wrong impression that medical evidence is contrary to the so-called eyewitness, because here main point is the eyewitnesses, they narrated only 4 injuries. Here there are 8 injuries, and they said with knife, with knife, with knife, with a long knife, with a short knife, they could not. And their perception, they have seen 1 or 2 injuries, that's all. They did not see all the injuries. It's not possible. They cannot give clear cut, this injury, this. Normally we write in 161 statements, but they will not tell like that. Same fact were told by the court, and Honorable High Court took into consideration and reversed the acquittal into conviction. Now the matter has come to the Supreme Court, as High Court has given conviction. Supreme Court also has gone into record and said that the contradictions given by the eyewitnesses, they are minor contradictions. They are not major contradictions. So as regards the number of injuries, please remember, different witnesses will react in a different way if they say such an incident. Some becomes dumbfolded, some becomes speechless, some will start wailing, and some will run away from the scene of offense. Is it not? But still, even in seeing that ghastly incident, these witnesses came before the court with courage, conviction, and belief that their wrong should be punished. So their evidence is 100% correct, and conviction given by the High Court is upheld. So please remember. So the eyewitnesses account cannot be contradictory merely because medical evidence is there. Medical evidence is there. But the important question is, even though injuries number 3, 6, 7 and 8 cannot cause death, the cumulative effect of the other injuries, if the other injuries are combined, definitely they will cause death. In so many murder cases, in the re-examination or in the chief examination itself, we'll be getting the doctor explain that if the injuries are clubbed, if the cumulative effect injury will be the death, consequential with death. Of course, I don't know why the PP at that particular point did not put that question. Of course, it's not material for us to comment on the judge also, on the particular PP also. Right? So here what you have to learn is the eyewitness's account should be given the most priority. That's what is to be learned from this case. So please read the judgment and enrich your legal knowledge. Thank you very much.